Welcome to Corporate and Commercial Practice. This module basically deals with contracts. So that's what we shall be looking into this week. But if you pay attention at the end of this video, then I'm going to give you tips on how to pass oral exams, and I will show you some of the marks that our students were given from their oral preparation. So please don't fear oral exams. If they can do it, you too, you can do it. So under this module, we are introducing students to structuring businesses contracts in modern businesses. Various contracts are entered into by individuals, corporate bodies, and government cater for specific business relationships and interests. It is therefore important that legal practitioners are given skills in structuring appropriate contracts that cater for the specific needs of their clients. A good understanding of clients' needs and structuring contracts properly to reflect these needs in an ambiguous manner is critical for the conduct of business. So well-structured contracts will avert conflict which arises out of ambiguity or unfairness in contractual provisions, and where conflict occurs, it will become easier for the parties concerned or an adjudicator to resolve the conflict and enforce rights, duties, and liabilities as per the contract. So as you can see from this introduction, this workshop deals with all forms of what? All forms of contracts. So they are trying to impart in us skills that can make you become a good draftsman, and basically as far as contracts are concerned. So workshop 1 aims of the workshop is to develop your ability to advise on the application of various legal principles relating in employment. So shall look at employment, which I think some of us did labor law at our undergraduate, but it's just an extension of that. But even if you did not do, don't worry. The Employment Act is very conclusive as far as employment is concerned. We shall look at agency, and of course the Contracts Act provides the law relating to agencies. We shall look at distributorships. For example, if you're given a distributorship to distribute Coca-Cola's products or maybe beer, then you're a distributor. Then franchise, we have all heard about KFC. We have heard about Cafe Javas. All those ones can give you a franchise. Then develop your ability to structure employment, agency, distributorship, and franchise contracts. So it's very, very important for you to understand who is an agent. For you to be an agent, you must be either appointed by authority, express or implied, and you must act within the instructions that you have been given as an agent. So the Contracts Act basically gives us a law governing agency. Distributorship, already the person is the manufacturer of the goods, then for you are coming to distribute. And a good example could be if you want to distribute sodas from Coca-Cola, then you can get a distributorship. Franchise, I have seen Cafe Javas. So if you want to make Cafe Javas in Guru, you can go and get a franchise. So to organize ESCO issues relating to employment, agency, distributorship, and franchise agreements. So we shall look at agency agreements, distributorship agreement, and franchise agreement. By the end of this workshop, you'll be able to explain the establishment of an employment contract and the silent features thereof. We shall look at the silent features of the employment contract to include scope of work, to include working hours, to include responsibilities or duties, to include termination notices, among others. So I believe that most of us have jobs, and we have looked at our employment contract because that can be an oral question that draft an employment contract. So please take it very seriously. So advise on the establishment of agency, distributorship, and franchises. So we shall look at the key components of an agency, a distributorship, and a franchise. We shall be looking at confidentiality and intellectual property, trademarks. We shall be looking at geographical territory, scope, and also mode of payment. Is it a commission? Things like that. But you have to pay attention to these contracts, because in oral exams they can tell you to draft any contract. So at least you must have to know the key essential features of that specific document. differentiate the different statutory rights of employees or employers. So what are the rights available to employers and employees? Rights to, of course, good working conditions, rights to be paid a wage, right to sick leave, rights to maternity and paternity leave, among others. Then structured transactions involving matters ancillary to employment, draft employment agency, franchise and internship agreements, and find deal with issues arising from these contracts. So assume that you have been hired as a highly trained legal and HR consultant by MK Power Industries Limited. Your terms of reference include to help the company set up proper HR resources in accordance with the law, draft an appropriate human resource management manual for employees, design a standard employment contract for different categories of employees, from the CA, CO to the drivers, give the company general advice on the mandatory statutory obligations required of it in the respective employees and the work environment. I have been given the following additional information. A, the company is engaged in the manufacture of energy-saving stoves which use charcoal or firewood. The stoves are called MKP EcoSave stoves. They are so efficient that they reduce energy consumption by over 60%. The company is constantly innovating and improving its products to achieve even higher energy-saving targets. The company hopes to venture into manufacture of energy-saving gadgets that use electricity and liquid petroleum gas in the future. These innovations are made by a group of scientists who are employed by the company. The company also works with interns in various engineering schools. These help out with research and are normally given a small stipend, as they are also trained and given critical skills necessary for their studies. So we shall look at the contract of apprenticeship. I think the Employment Act defines the contract of apprenticeship. Then the company employs various casual laborers. Even the section 2 of the Employment Act defines who is a casual laborer. If basically you are being paid on a daily basis, then you are referred as a casual laborer. For example, those people who work on construction sites who are paid like 10,000 a day, then they are referred to as casual laborers, who collect clay for use in the stoves, mix the clay with certain chemicals, components in the stoves, and set the stoves into kilns where they are subjected to temperatures of about 650 degrees Celsius until they are allowed to cool naturally before being subjected to very cold nitrogen to harden them further. This cooling process has temperatures as low as 10 degrees Celsius. There is also use of heated iron and steel parts in the process. The casual laborers are normally busy from January to April, and then most of them are laid off until the next year. And this is because by April, most of the materials required for production during the year has been prepared. The company also engages the service of carpenters, welders, and mechanics who come in as and when needed to repair and fix broken furniture, metal and works, and machinery. The company relies a lot on labor of women and school-going children during their holidays. Those who are not in school work anytime they are needed. So basically here we are looking at under what conditions can you employ children workers, and of course children workers can only be employed when they are doing light work, to include cleaning and washing of utensils. The company wants to tighten its financial belt by strapping benefits such as lunch, break, tea, drinking water, and reduce medical cover from employee spouse, plus for children covering only employees. The company also wants employees to contribute towards the purchase of PPE needed at work, deductible from salary and wages. Because of this, the company is worried that members of staff may help themselves in company stores and parts used in the production process. The company wants to forestall this before a disaster strikes. Any employer caught will be got rid of there and then. So basically here we are looking at the rights of workers. At what point are you allowed to carry out deduction? The Employment Act provides for allowable deductions, or what we call permitted deductions, and also right to privacy. Can you just employ cameras when you have not given notice to the workers? So at any one time there are at least 150 persons working at the factory, in offices, and on the production line. There are also heavy trucks bringing raw materials and loading finished products to transport them to DR Congo, Sudan, and Rwanda, where there is a huge demand for the products. About 60% of the products are exposed where the rest are sold in Uganda. Because the company pays a good hourly rate, some employees in production work until their limbs cannot move them any further. They take brief naps before assuming work, but they're extremely happy because of the pay. They want to suffer now and kings and queens later. So all necessary approvals before production could commence were obtained. You are not required to advise them on You are not required to advise on them. It's only human-related matters you have been asked to handle. The company wants to bring an expert on energy using stores from Turkey to help them turn the company into a world-class entity and compete globally. Mr. James Mungai, Kenyan national in Turkey, has been identified. So basically here we are looking at how do you employ foreign workers. First and foremost, of course, we have how do you employ foreign workers, whom the act refers as migrant workers. And what is important for you to understand is that they must be having a work permit. So the first task we have here, advise the company on the legal status of the different categories of persons. So first and foremost, Section 2 of the Employment Act defines an employee to mean anyone who works for remuneration. Also Section 2 defines an employer to mean a corporation, but to mean a corporation, but however they exclude those of UPDF. They exclude those of UPDF. So of course you have different tests you have to apply for you to determine the employer-employee relationship. One, you have the control test in red mixed concrete limited versus the Ministry of Pensions. The court was saying that we have the integration test, multiple test, as well as basically integration test and also multiple tests. So the court looks at all those tests to see whether there is an employer-employee relationship. And the integration test, it means what part does the role you play in the whole business. So that's what we call integration test. Is something part of the business or is something different from the business? Then multiple test, we are meaning that are you paid a salary? Do you have an employment contract? Things like that. But it's very, very important to understand those tests when you're going to define the employer-employee relationship. So we have the CEO, who is a migrant worker under Section 2. We see that a person who migrates from one country to another with a view to become employed is called a migrant worker. Then we also have casual workers, who called casual laborers, and Section 2 defines the casual employee to mean a person who works on a daily basis or hourly basis and is paid an amount. Then also have interns. Section 2 also defines a contract of apprenticeship to mean a contract of service. So you have to look at all those things as categories of workers. Then from the facts given, design a matrix clearly identifying the mandatory human resource and related compliance issues that must be addressed. So when we talk about the human resource issues, first and foremost, human resource, we have all heard about human resource department at our workplaces, or maybe some of us are human resource managers. But when we talk about human resource, it basically deals with employment issues, recruitment, up from recruitment to conditions of workers, up to retirement or termination. So that's the department required for that. So basically it deals with requirement and employment, compensation and benefits, working hours, employee safety policy, and also termination and resignation. So basically this is the department that handles issues related to workers. So the regard of the intended austerity measures the company wants to undertake. So basically here we shall look at withdrawal of benefits. Remember, we have deducted or allowable benefits that are allowed under the Act. You cannot just withdraw money from employers when they have not consented, or maybe there is a law that provides for them. Then also have surveillance cameras, Article 27 about the right to privacy. If you're going to introduce cameras, then there must be a notice. If you have been in most of the buildings where there are cameras, you will see notices that surveillance cameras are in this building. You don't want to be caught by surprise, where you are assuming that you have a right to privacy, whereas in actual sense, you don't have. So for what provisions will you include in the human resource manager, the human resource manual you have been asked to design? So here the provisions, of course, we shall look at internal and casual workers policy, working hours and compensation policy, work safety and health policy, and employee code of conduct policy, among others. Then what policies will you put in place to ensure effective running of human resource operations? We have looked at that. What provisions will you include in the human resource manual you have been asked to design, not draft the manual? So the provisions that in the human resource manual, of course, there must be there must be the provision about recruitment. How are you going to recruit your workers? And then after that, you have to talk about conditions of pay, all those things. So basically, human resource manual is the document which governs the recruitment of workers, their rights, and how are they going to be protected, disciplinary, among others. So after the next issue is what is the legal basis for this process, explain the legal relevance of this process and their binding effect. So first and foremost, all of these policies I introduced by the what? I established by the Employment Act. For example, when we talk about a recruitment policy, you have to understand that the recruitment policy is provided for by the Constitution, that you cannot recruit people who are minors, but also there is a procedure for you to recruit people who are what? Who are migrants or maybe foreign workers. So in discussing the legal relevance and binding effect, the legal basis, you look at the law, the relevance, you look at also the section of the law, and the binding effect is always produced by what? By the statute. In case you don't comply, then what happens? For example, here we shall be looking at first and foremost the employment contracts, that there must be an employment contract. Then secondly, we shall look at compliance areas, working permits, salary deductions, which are established by what? By the statutes. So those things shall be looking at to handle task 5. So task 2, what legal requirements will you need to fulfill before employing Mr. Mungai? So Mr. Mungai is a foreign worker. So for us to employ foreign workers, we shall proceed under what we call Section 2 defines a migrant worker as a person who migrates from one country to another with a view to being employed. But basically, when you look at Section 59, bars foreign nationals without an entry permit to come and work in Uganda. So when you look at the Citizenship and Migrations Control of 2004, you need to apply, and then you must attach your passport photos on that application. The company must also attach a VAT tax clearance certificate. Applicants must have in possession an appointment letter, and also upon approval and payment of necessary fees, an approval letter is generated and provided to the applicant. And then when office is satisfied with the requirements presented by the applicant, shall issue the entry permit to the worker. So basically, you have to apply to this Citizenship and Immigration Office, who basically gives you a permit, and you must fulfill these conditions that prove that work cannot be done by a Ugandan. Attach a tax clearance certificate of the company, appointment letter, as well as your passport photos, among others. Then draft an appropriate contract for the CEO. Of course, the key provisions here we have position and duties, term of employment, remuneration and benefits, performance expectations, leave entitlements, confidentiality, disciplinary and action, and termination. Then a standard form which can be used by the company. This standard form has appointment, duration, the employee's duties, working place and hours, then remuneration, deductions, annual leave, sick leave, termination and dispute resolution, among others. So this is standard form contract which can be used by the company to copy and paste and according to the work they have. Then part B, when you look at part B, what we are doing with is they are saying that, assuming that Mr. Mungai has exceeded all expectations and the company's annual sales are now exceeding USD 30 million, James Mugaga, an entrepreneur, had set up a strong chain of outlets that were selling Heineken beer across the country. He has recently become a born-again Christian, has the necessary tracks to move the stove rapid across the Uganda. Mugaga, being a smart businessman, does not like to tie down his capital. He wants to access the products of MK Pie on credit and pay after he has sold them. So basically here we are dealing with what we call distributorship, which we talked about, that where you have a manufacturer with your goods, then for you can just apply to be a distributor. And the only way you can apply, you can understand a distributorship is when you look at the relationship of Coca-Cola and Pepsi. Those are the ones which can enter distributor. So you have a manufacturer, you just come in to distribute the goods. So this contract must have of course, commencement date, territory of supply, terms and termination, pricing and payments terms, performance targets and marketing, and dispute resolutions, among others. But those are the key clauses. Then task 4, assuming that the business acumen of Mr. Muganga and his wife through their company has impressed the Cafe Javas proprietor, the owing Javases, they have agreed to venture into a business. So basically here where you have things like Cafe Javas, you go into a franchise. Basically in a franchise, you want to copy and paste the business system. You don't want to reinvent the wheel. Something is already there and it's working, so you go for a franchise. And of course a franchise can be described as a form of business organization which a firm which already has a successful product or service enters into a continuing contractual relationship with other businesses. So we can have product distributorship, business format franchise, and also manufacturing franchise. Sorry, this is about franchise, not distributorship. So what you have to understand about a franchise agreement, it has franchise fees and royalties, terms and renewal, geographical territory, then quality control, marketing and advertising, as well as dispute resolution, among others. Then part C, we have assuming that further that MEL has sensed a great opportunity to help MultiChoice Uganda Limited extend its operation in Wenzori area, this district of Fort Portal, Kasese, Bujo. So basically here these ones have agents, and we always hear them of advertising on radio that our agent is here. So basically these ones have agents, and of course agents is defined in section 1.1 of the Contracts Act, 117 and 118. An agent is a person employed to act or represent a principal in dealing with third parties. And the agreement here we have is an agency agreement. The key clauses, we have appointment of agent, duties and obligations of the agent, duties and obligations of the principal, commission and payments terms, intellectual property confidentiality, liability and indemnification, terms and terminations, among others. Then part D, we have assumed that MKPI has grown so much and has thousands of customers. It wants to set up a robust call center to receive and handle complaints of powered cooking equipment. However, MKPI does not want to increase its headache of dealing with many employees. So basically here we have what we call outsourcing. We have all heard about outsourcing, that when a company wants to employ people but it doesn't want to pay, it can also go for outsourcing, whereby, for example, you get people who are outside but they are working for you. That's what we call outsourcing. For example, if you don't want to make a marketing department, you can go and hire a company and does the marketing department for you, so you don't have to pay anyone a salary like that. That's what we call outsourcing. So of course we have the case of National Social Security Fund versus MTN and Unisys. The plaintiff sued the defendant under recruitment of services contract, under which the defendant was to provide skilled and competent temporary staff for assignment required by MTN Uganda. So basically it's also called outsourcing agreement, or maybe a recruitment of service contract. So the due diligence you have to make, one of course is legal status and registration, where the company is registered, the track record, financial stability, and data protection. So this recruitment of service contract, it basically has scope of services, terms and termination, service level agreement, compensation and payments terms, and confidentiality and data protection, among others. Then part E, assume further that sourcing has grown in leaps and bounds, now wishes to take advantage of opportunities presented by an employed youth in Uganda who would like to go into Qatar. So basically, how we are talking about how to export labor or labor export. And you have the employment recruitment of Ugandan migrant workers abroad regulations of 2021. You must first establish a registered company, and then after having an incorporated company, you ask for a recruitment permit. Then if you have the recruitment permit, then you can proceed to have a training center, and you can recruit people to do what? For abroad. But of course, we have the regulations of 2021, which governs this area of how basically do export labor. So what measures should they take into place to protect the interests of the person they help? One, transparency and fair recruitment process. You must be fair, because we have situations where people take people abroad expecting fancy jobs, then they reach and they find they are being housemaids. So you must be very clear to the people. Then pre-departure training, you have to make sure that you're training your workers before they leave, so as they can go, they can know what they are going to be doing, doing. Then establish work monitoring and support systems in case there are issues, how they report to you. Then part F, assume further that workers in MKP are getting disgruntled. They see the company grows in leaps and bounds, but their wages are not being increased at the same rate, and yet they are the ones who make this happen, while managers are busy sitting in air-conditioned offices. So management has heard about this plan and has voted not to allow this kind of thing to happen. Management will not let anarchy, which is reached by a labor union, reign. Management is not happy. So assume that you have been invited by management of MKPI and representative workers. The two camps believe in your wise counsel. Do not disappoint them. In a 5-minute simulation, advise management and workers on the role of labor union versus the expectation and fears of the parties, the merit of setting up a labor union, how the interests of the parties can be protected, and the importance of collective bargaining agreement. So basically here, first and foremost, Article 40 of the Constitution gives every worker a right to form a trade union. It should be read together with Article 29 of the Constitution, Freedom of Association, and Section 2 of the Labor Unions Act, which basically provides that employees have a right to organize themselves into a labor union. Then what the models of setting up a labor union? Section 14 of the Labor Unions Act provides that an application for registration of a labor union must be made to the Secretary General or any other officer of the organization seeking registration as a labor union. So you must make the Secretary General of that union makes an application. Then Section 14 to provide that an application of registration may be accompanied by certified copies of the Constitution and the rules of the organization. So the name of organization, it must have the name of the organization, the numbers, titles, among others. So we have heard about trade unions. For example, we have the UNATU for teachers, we have MAUSA for Macquarie University lecturers. Those are the ones which we are talking about. I don't know whether LDC has one, but at least we have had one at MOC and also one of UNATU. But you can see where there are trade unions, then strikes are always the norm. So what's the best way to protect the interests of all parties? Section 2, every person have a right to join trade unions. So you can recommend open dialogue forums, transparent wage review mechanisms, and addressing workplaces concerns. Issue 4, what's the importance of collective bargaining agreement? So a CBA is the form of agreement between the company and the union that organizes key employment terms. So a collective bargaining agreement, instead of a company having an agreement with only one worker, it becomes like a standardized form for all workers in that trade union. So basically, it increases the bargaining power, and people are not always cheated. Task 2, as part of MK Power Industries, the company is concerned that becoming hostage to employee demands. Which strategies can ensure that the management does not become hostage to the demands of employees? So basically here, so I assume that you were part of management, have listened to the presentation, you have been tasked to come up with strategies to ensure the management will not become hostage. So first and foremost, build a strong internal employee relationship framework, competitive wages and benefits policy, develop a proactive communication strategy, recruit a balanced workforce, and you can also look at using AI, because AI now can do most of all those work. So basically here, that was it. We also looked at trade unions, and that was it for this work. So please, in case you need detailed notes and discussion in detail, you can join us in preparation for orals. We have already begun preparation for orals, and remember, we did it with the first intakes, and we have students who got extremely very good results. Where we have students above 25, and I promise to share those results at the end of this video. So please, if you see at the end of this video, then you will see those results, and I pray that you become motivated. So workshop 2, the aim of this workshop is to develop the ability to explain various legal principles applicable to insurance and construction contracts, develop the ability to structure specified contracts such as insurance and construction contracts and service level agreements organized with ESCO issues. By the end of this workshop, you'll be able to explain the rights and obligations of parties in insurance and construction contracts, structure construction contract, structure an insurance contract, draft an insurance and construction agreements, negotiate a service level agreement, and identify and deal with ESCO issues. So basically here you can see that we are dealing with contracts, and this is not procurement. This is just also contracts, because students always confuse this with procurement, but this is not procurement. It's entirely on contracts. So Road Development Center has decided to take e-learning to another level. To the end, LDC has decided to contract a 12-floor multi-purpose hall with state-of-art from rooms and lecture theaters with full video capabilities. The intention is students should get a 3D of the classroom even if they are attending class remotely. Let me run the questions. The director specifically made the following deliverable clears to you as part of your performance indicators. Advise the payment of Uganda shillings 650,000 requested by the contractor. The director wants strong and binding undertakings. All further payments will be made against construction milestones. Task 1, advise LDC on the risks involved in a project considering circumstances. So basically, you have to just apply your construction knowledge. Apply just your construction knowledge, and here we shall be looking at, of course, Regulation 6 of the Public Procurement and Disposal of Public Assets Contract Regulations, which basically provides for these risks and how the contract can be awarded. So we have the financial risks, government funding and shortfalls, contractual risks like failure to conclude work in time, operational risks like damages, legal and compliance risks like non-compliance with regulatory standards. So those are some of the risks, how they can be mitigated: financial risks by budget adjustments, contractual and execution risks by insurance, operational risks also by insurance. So basically those things we shall be looking at. Then task 2, what security should LDC take for the advance payment? So we shall be looking at performance security. Basically, performance security is a guarantee you make for your quality performance, and we can have a performance security, or what we call a performance bond. And this performance bond, you can have it, for example, where the bank gives a performance bond that in case you don't do quality work, then they will be in position to pay you. So basically, that's what we are calling performance guarantee or performance bond. Then from there, we shall look at also can get a bank guarantee, where the bank guarantees to pay in case there is any failure to comply. So issue 2, what undertakings should LDC obtain from the contractor and professionals involved to protect LDC in the event of poor execution? We looked at first and foremost contractors undertaking quality work, liability for poor execution, financial undertaking delays, and insurance coverage. So basically, this is you have to apply your construction knowledge. I believe at least we have seen construction. They have either built homes or anything I've looked at when they are building. You just have to apply that knowledge you have. So what's the property document? We drafted the performance guarantee with the bank. Performance guarantee with the bank, which basically helps us to do that performance guarantee. Then from there we looked at what is the draft of the contract between LDC and ZCL taking care of all concerns raised. So this contract has, of course, it's like other contracts, but it has scope of work, completion of work, performance and security, obligations of the contractor, warranties and liability, termination, among others, and also dispute resolution. Then part B, assume that the project kicks off 1st July, has over 200 workers that will be working on the project, including engineers, drivers. So what is the process of enabling successful handover of the site so that works can begin? So site inspection and documentation, site handover agreement, safety and security measures, provision of utility and resources, initial safety and environment briefings, and document handover. So basically this is how basically you do handover in what? In buildings. Then what process would you expect from this year covering all risks? We have construction all risk insurance, public liability insurance, employers liability insurance, workers compensation insurance, machinery and equipment insurance, environmental and pollution liability insurance, and professional indemnity insurance. What clauses would you look out for in the policy? Work injury and death, third party liability, subcontractors, policy duration, and also subrogation rights. What is the checklist which will enable the director to approve the policy? We look at things like insurance coverage, deductibles, subrogation rights, among others. Then part C, we see that they're saying that LDC seeks to hire more logistics, supply video conferencing, and the system will be linked to a control center for class recordings and an access control. So what process can the director follow? Measures which should be taken to ensure that LDC gets value for the money? So here we looked at things like technical due diligence, secondly, clear specifications, licensing and cost control, risk management and warranty, regular monitoring and evaluation, and also auditing. Then task 5, LDC has hired Shirek Telecom to provide internet connectivity through fiber optics and leased lines, given the critical nature of the service, especially during classes. What are the components of service level agreement? So the service level agreement is the one which states the expectation between the contractor as well as the manufacturer or the service provider. That's what we call a service level agreement. So it has a definition of scope, performance standards, and monitoring and reporting, penalties and remedies. So what are the ESCO components? We look at service scope, service availability and uptime, response time and resolution, monitoring, reporting, and performance metrics, among others. So basically that was it for workshop 2. A lot of theory here. Please don't fear, just focus on understanding because these are very practical things. Don't get lost into the words, just focus on understanding, but they are very practical as they can be. So let us go to workshop 3. I don't want to take a lot of your time. I understand it has been almost half an hour on this call, so let us try to summarize and give you the basics so as you can go and fill in. But these kind of things always comes in orals, so you have to at least have an idea. If you talk about the service level agreement, what does that mean? And I'm saying it just sets the expectations between the service provider and the client. So if you know that, that means if they asked you components of service level agreement in an oral question, then you cannot lack where to start from. At least you can begin from there. So as far as workshop series is concerned, the aim of this workshop is to enhance your ability to identify contract of sale of goods and supply of services act, develop ability structure a sale of goods and supply of services contract, advise on key aspects of insurance on sale of goods and supply of services contracts, recognize ESCO issues, learning outcomes, identify the key tenants of sale of goods and supply of services contract, advise parties on their respective rights in a sale of goods and supply of services contract, draft a standard form contract for sale of goods and supply of services, advise on key aspects of insurance in sale of goods and supply of services, advise on remedies available. So basically, as far as the first part is concerned, we can have Money Trading Limited imports new and conditioned vehicles from Dubai. They offer aggressive marketing. MTL provides warranties on new cars, but it is conscious about power maintenance. So issues: what are the different contractual relationships as disclosed by the facts, rights and duties? So the different contract relationship we have under the sale of goods contract. We have supply of services contract, but also we have contract for sale. So we have agreement to sale also, because when we talk about agreement to sale is where provided where they transfer the property and the goods is to take place at a future time, then that one is always referred to as agreement to sell. Whereas contract for supply of services, we mean that it's Section 3 defines the contract for the supply of services to mean a contract where a person agrees to carry out a service, whether goods are transferred or are to be transferred. So basically, you have to understand the difference between agreement to sell, contract for supply of services, and contract to sell. So where the property and the goods is transferred after the payment of a monetary consideration called the price, then we say there is a contract to sell. So please understand the difference between agreement to sell, contract to sell, and contract of supply of services, because that can be an oral question. Rights of the seller. Of course, rights of the seller, we have them under section 51, that the seller has rights to be paid for the goods he supplied, and also he can retain goods or stop them in transit as a lien. Rights of the buyer, of course, to examine the goods, to receive goods of right quality and specification. Then from there we looked at what's the best way of protecting MTR against risks. Of course, insurance coverage, clear terms in the contract, and inspection. Then we have the standard form contract here, which we drafted of sale of goods. We have the sale of goods payment terms, delivery, warrant and liability, transport and risk dispute resolution, force merger, among others. Then task 2, we have Bentley order by Mr. Moses Dalton Warkaga was destroyed in a fire after a car carrier. So basically, I think we looked at the exclusion clauses and at what circumstances are exclusion clauses going to be binding. And we said that the exclusion clauses can be binding when they are properly brought to the notice of the what? Of the other party. So this part 2, the track filed, we have Bentley ordered Moses Dalton Warkaga was destroyed in a fire after a car carrier collided with a truck which was illegally parked in Madura Forest. So basically, here we look at basically insurance and who bears the risks and how do you claim under that insurance. So what are the rights of Dalton? Right to claim under the insurance, right to compensation, whether PDF has any rights in the circumstances, right to investigate the claim, right of subrogation. Subrogation means you can recover from a third party. If basically my car was knocked and the insurance pays me, the insurance company can sue that company that knocked my car. That's what we call basically subrogation. Task 3, we are looking at, of course, exclusion clauses, and we are saying that the exclusion clauses must be brought proper attention of the next party, of the other party, and that's why we have cases of London and Brove Haken versus Pipe, among others, that for exclusion clause to be properly not binding, it must be brought to the proper notice of the other party. So whether MTL has any rights in view of landlord's refusal to pay, right to enforce the contract, right of lien, and right to claim damages. Task 4, we have John's Mobile purchased 2 cars from MTL for personal use and Renant for resale. Jones drove off with the capture. He later discovered the boss cars had non-conditioning systems. So basically here we're looking at whether the goods were fit for purpose, and this is an implied term in section 4 of the Sale of Goods and Supply of Services Act, as well as section 15, and where the goods are not fit for purpose, then you can either return them or claim for damages. Whether MTN has any liabilities, so we can look at section 12. Provided the breach of a warrant and that is the party to damages, while a breach of condition is given rights to treat the contract as repudiated. And we have the case of Honorable Mabo Bakaine versus Yausa, where they bought a car from Yausa, and then after that we can see the car was in bad condition and they tried to return them. So that's, you can read that case, Mabo Bakaine versus Yausa, on implied terms in the Sale of Goods and Supply of Services Act. But what you have to understand about sale of goods, we have an implied terms in the Sale of Goods and Supply of Services Act, and it basically means that those goods that we have implied term as quality, implied term as title, and implied term as the goods matching with sample and description. So those are some of the things that are implied by the Sale of Goods and Supply of Services Act. But please don't fear the context of this work, because most of it, when you read the acts, if you can read the Employment Act and Sale of Goods Act, then most of this has been covered. So please, in case you want to prepare for orals, we have oral discussions already ongoing. If you can afford the cost, then you can come and we give you the confidence and we make the journey easier for you. But also, if you cannot, then of course you're good to go. You don't need to be coached for it to pass orals, as long as you have understood the context. But you have to put in extra hours, because I believe that what can take me 1 minute to explain for you to understand, maybe you might need 1 hour to read it. But at the end of the day, what matters is, did you understand? So I'm not trying to sell to you on mentorship, because we are basically targeting students who can afford and don't have time. Maybe they work, they have families. That 100,000 per month is not much money to them. So those are the students we are really targeting. So if you cannot afford that 100,000 per month is maybe your pocket money, then that means you are not our target market. And that's why we have decided to make this YouTube video for you, so as we can also help you understand the context of the workshop. But of course, I want to leave you with a screenshot of some of the students, of the marks they got in their orals from the first intake, and I hope that you become motivated. Please, if they can do it, you too can do it. We remain the Pass the Bar team.